So with that all said, I am thrilled to introduce today's presenter. Andrew Salinas is a two-time Texas Rising Star by Super Lawyers and a member of the National Trial Lawyers Top 40 Under 40 recognitions reserved for the most accomplished attorneys in their fields. As a founder and managing partner of Salinas Defense Firm, PLLC, he has built one of Houston's premier criminal defense practices, securing hundreds of dismissals and favorable outcomes for clients facing life-altering changes across Texas and beyond. 2025 Texas Trial College participant and NHTSA certified attorney, Andrew brings courtroom tested experience across Harris, Montgomery, Galveston, Jefferson, Matagorda, Travis, Bastrop, Burnett, Bell, Bexar, Williamson, Lee, and Hayes counties. So pretty much all around Texas, as well as New York criminal courts. His clients have faced serious felony and misdemeanor charges, and his results have extended beyond criminal defense to include securing multi-million-dollar judgments in plaintiff litigation. And with that, I will turn things over to you, Andrew, to kind of tell us more about your practice and about defending Texas immigrant communities.
Sure. Well, thank you for the introduction. Thanks everyone for being here. Again, my name is Andrew Salinas. Born and raised Houston, Texas, first generation lawyer. I know nowadays, especially with everything going on with the news, everyone's really interested in immigration and what it looks like to defend immigrant clients, especially here in Harris County. So I'm happy to give kind of like an overview of what my day-to-day looks like. Hopefully, I know not everyone here probably practices criminal, so it's going to be a little bit of probably a refresher maybe from law school of what the criminal process looks like, and then what specifically it looks like in Harris County, just generally representing clients, and then also representing people who not only have a criminal charge to deal with, but also have to deal with potential deportation. So from the top, this is kind of just like a roadmap of what we're going to do. We're going to go through detention and bond, what necessarily a win looks like, Sixth Amendments, kind of knowing how and who you represent, talk a little bit about immigration law, because there's a difference between who's inadmissible to enter the United States and then who's deportable, which is very nuanced, and we'll get into that. We'll go over the difference between a conviction and a sentence, and how, what might be a good deal for a citizen would not be a good deal for a non-citizen. Kind of go into what type of convictions, what type of charges are red flags, so kind of for danger categories, and we'll kind of go over that. So kind of go first, just detention bond, and what does a win necessarily mean. So just as a refresher, right, or for people who aren't familiar with criminal justice system in Harris County, here's more or less kind of like an 8 stages of how a case starts, right? So an arrest starts, someone gets sent to processing, their biometrics are taken, within 48 hours they have to go through magistration, right? So probable cause, that's where bond is given. Whether they're released or not is determined at magistration. The DA does their intake, and for felony cases, they can decide whether to do a grand jury. Part 6, this is what takes forever. I'm sure, obviously on the civil side, discovery also takes forever, but this is where it just takes a long time, where you're constantly resetting cases, waiting for discovery, reviewing discovery. And then 7, where the case ends. So either you get that case dismissed, you get a plea, or you take it to trial, or for the client, you might go to supervision, right? So probation, community supervision type of probation. That's like the general clock of what happens when someone's arrested. Now you'll notice here with booking that this here biometrics, it's in red. And so the reason for that is because of this. So everyone who gets processed, or I should say mostly everyone who gets processed, has their fingerprints taken, And once their fingerprints are taken, it goes through a database, NCIC. So it goes through FBI, DPS, DHS. And if you're a non-citizen, sometimes what happens is there's a record hit. And whenever that happens, you get a detainer. So what a detainer is essentially is it's telling the courts and telling the jail that it doesn't matter whether this person posts bond, whether the case gets dismissed, or what have you. As soon as that person is deemed to no longer need to be in custody in jail, they're going to go to immigration detention. Generally, it's a 48-hour window is when they'll be able to do it. Now, in the past, I want to say the first Trump administration and then Biden's term, there was actually, sometimes there was a chance that that 48-hour window would pass and these clients, these defendants would be able to actually walk from the jail. But since Trump's second term, it's like a 99.9% likelihood that they will get picked up. And if you're dealing with clients here in Harris County, 99% of the time they're going to end up in the Conroe Detention Center, the Joe Corley, detention center, which is about an hour away. So these detainers, a lot of times they'll kind of be random. So I've had clients who have been in the country unlawfully, right? They've been in the country maybe 20 plus years. They'll tell me, Andrew, I've never had a parking ticket, even, and they'll get hit with an ICE hold. Sometimes you'll get someone who just got here recently, so maybe a year or two, doesn't really have any ties with the community, and they don't get an ICE hold. So sometimes it is kind of like a crapshoot of who ends up getting an ICE hold. I have noticed though recently, I'm not on the law enforcement side, so maybe there was a change, but I have noticed that the likelihood that someone who wasn't has been here more recently, the chances that they get an ICE hold has increased since the second Trump administration. So what does a hold do to your case, right? So it really changes the flavor of what you do when you're representing a client. So, already there's a lot of statistics. I don't have it here necessarily, but statistically, whenever a client, a criminal defendant has bond, is out on bond, the chances that they're able to get a more favorable outcome on their case. So that means taking it to trial for an acquittal, getting a favorable plea deal that leads to a dismissal or maybe a deferred adjudication, some type of favorable probation. That goes up because they are, obviously, they're not in jail. They're able to aid in their defense, and it's from our position, they have there's a better bargaining position because they are on the outside, they are more willing and able to go to trial. Whereas when somebody is in jail, I can't tell you how many times this happens. This is a very, sorry, so I'm trying to talk. Okay. I can't tell you how many times this happens. It is a bit heartbreaking. But, I've had plenty of cases where, I look at the evidence and I tell my client who's in jail, who either has an ICE hold or, for whatever reason their bond is too high and we're not able to get it lowered, that if we were to take it to trial, the chances that we could get it dismissed or get an acquittal are pretty high. But they look at me and they say, I've had a client specifically tell me, Mr. Salinas, Attorney Salinas, every day that I spend in here is hell. So, me, obviously with our attorney ethics, right, we have to go with what the client wants. And who am I to tell a client, well, we'll get it dismissed. You just got to sit here for another, 2-3 months of jail. So obviously, when someone is unable to post bond, that materially impacts their case. So when it comes to immigration bond specifically, so you can kind of see here, jail credit accrues only on one side. So that jail credit only accrues for the county It has nothing to do with immigration. Personal bonds aren't, a lot of times they're denied if someone does have an immigration hold. A lot of times if a family member unknowingly posts a bond, say they pay the $1,000 or thousands of dollars, and their family member ends up going to the detention center, the likelihood that the detention center brings their family member back to criminal court is near zero. So essentially, it's like the person paying the bond loses out on all that money, and the person gets a warrant for their arrest. So a lot of times, what I tell clients is, we gotta beat your criminal case, because as much as you want to go to maybe post a bond and just go to immigration, and maybe you want to just sign the voluntary departure and head back to your home country, that warrant is going to last forever. So that's something that really it heightens the stakes whenever there is an ICE hold, and it completely changes because any PTI, that's pretrial intervention, any type of plea bargaining that can lead to a dismissal or something that's just more immigration friendly, it gets near impossible when they're in jail, because it either becomes they need to go to trial, right, to get an acquittal, or they just want to do what's known as a time served, which is, right, they take they plead guilty, it's a conviction on the record, but to them, they think, well, I'd rather be free, go the immigration process, get deported, and be free in my home country than spend time in the jails here. So this is where I kind of got ahead of myself here, but that's where it kind of like, what does a win look like? So this is something that any defense attorney, but especially if you're dealing with undocumented people who have a detainer, you got to ask them, what does a win look like, right, for them? So it obviously, you think win might be a dismissal or an acquittal, which of course I would count that as a win as well. But if the alternative is sitting in jail for 6 months, potentially, or over a year, a lot of people are going to choose the time served and say that's more of a victory. I have a case right now where the offer is for 2 years in prison, and so the client, to us, the win is going to be getting a time served, and so that's kind of the win for him, would be not having to spend 2 years in prison, even if it means sitting in jail trying to push the prosecution to get a better deal. That's just kind of the reality of what we're looking at here. And does the client have the path? A lot of them, I find that a lot of clients are very clear-headed when it comes to their options, because they're in jail, they kind of look around and they see other people that are similarly situated to them, and they realize, like, wow, I gotta really decide what's gonna happen here. So that's kind of what a general case looks like, a criminal case looks like here in Harris County, and how when it becomes an immigration detainer and bond doesn't become possible, that's what that looks like. So now we're going to go into what is your Sixth Amendment duty when it comes to dealing with non-citizens, right? So Padilla versus Kentucky, that's kind of like the cornerstone case for this. That was decided in 2010. Essentially, the holding of it was that defense counsel must advise a non-citizen.
I'm on a CLE webinar, so don't.
All right. If we could mute, please. Thank you. But yes, Padilla versus Kentucky. I'm sure we've all heard of it, but just as just so you guys can see, counsel must advise non-citizen whether a plea carries a risk of removal. Right. So this answer of if you can see my mouse, you should be fine. That's affirmative misadvice, and for Padilla, that's deficient performance. So this is actually something that Supreme Court said is will qualify as ineffective assistance of counsel. I'm sure all of us kind of remember that. Well, at least me. I was in law school 2017 to 2020. I remember reading a case out of Texas where I think it was a murder trial where the defense counsel fell asleep during closing arguments, and the defendant was convicted and appealed. Said that was ineffective assistance of counsel, and the Texas Court of Appeals said that did not fall below effective assistance. So, with that backdrop, obviously advising a non-citizen about removal, that kind of gives you an idea of how serious the court determined advising people about that was. So, it's kind of like the Strickland prong 1, prong 2, right? Did the counsel fail to give advice to Padilla? And then would a rational defendant in the client's position have rejected the plea and gone to trial? So it's not would they have won at trial, it's just would a rational person have elected to go to trial rather than take a plea that, obviously would have resulted in deportation. So, here this is just talking a little bit about proving prejudice. Defendant doesn't have to show that he would have been acquitted. This is more just, a practical point. And I'm more than happy to send this PowerPoint presentation to, anyone who wants it, if you want to get your hands on some of the case law or some of this. But this is just talking about, if you are going to be representing non-citizen clients, it's a good point of practice just to get what's known as a Padilla advisal. There's a lot of great nonprofit or organizations that will give you Padilla advisals. I know here in Harris County, the MAC, that's a appointed managed assignment counsel for misdemeanor cases here in Harris County. I know that they have a Padilla advisal on call, so you can kind of get that, which is very important when you're dealing with, specifically when you're dealing with felonies, right? So that's just something to really keep in mind. This is kind of just more talking about, every time that someone takes a plea in Harris County, it doesn't matter whether they're a citizen, a non-citizen, whether it's for a Class C theft or for a murder charge. Everybody gets a form that has a Padilla advisal, and so that's just something that the courts do, that they require for every single plea deal that goes. But that's not going to protect you necessarily. That's not going to be a shield, 100% foolproof shield against getting a writ or an ineffective assistance of counsel claim against you either. On the other hand, it also cuts against someone who's trying to apply for habeas, because obviously the state can point to that and say, well, this was written in English. And a lot of times, at least in Harris County, the plea paperwork is exclusively only in the English language. So, the other counties will offer it in Spanish. I know at least Harris County, it's only in English. So, that might be a form of attack, saying that maybe the interpretation was not exactly great there. So, the form there, it says, this may result in deportation. This plea will make you removable. So this is why it's really important to get with an immigration attorney. Get with there's ALA, there's ILRC, there's local resources. So when in doubt, even if you can kind of look up whether a plea would not necessarily result in deportation or exclusion, it's always a good point of practice to speak with an immigration attorney. So moving on to section 3. So, know who you're representing, right? So you never want to assume whether someone is a U.S. citizen or not. I can tell you there are plenty of Spanish speakers that I've dealt with that are full-blown U.S. citizens, that, it's just Spanish is their first language, and it's their preferred language. But they're, you would obviously you think, okay, well, they're not speaking English to me, so they must be a non-citizen, but that's not necessarily the case. Same with lawful permanent residence. With DACA, that's something that a lot of people have to deal with. So that's just something that, whenever you deal with someone, when I'm representing like a new client, that's one of the first questions that I ask during intake is, are they a U.S. citizen? And if not, then, do they fall under any of these other categories? So this is just more, again, I can send this to anyone who wants this slide. It's just, and this is also a good point here is, a lot of people will say, oh, I have my green card, I have my permit, I have my papers. But, a lot of them don't actually understand necessarily what that means. So they might have gotten a green card, or they might have gotten a work permit and thought that, oh, well, that just means, I'm good forever. But obviously that's not the case because, things might have happened. They might have lapsed because they've gotten a conviction in the past. They were no longer eligible to renew. So you really do have to be diligent in getting their immigration paperwork. So, what that can look like, you can either get your hands on the paperwork from the client. Sometimes you can go and ask the immigration attorney that got them whatever status they received, or you could always do a fun FOIA to immigration to get someone's like full immigration case file, and depending on whether they're in custody or not, that can either take less than 30 days or it can take a few months, just depending. So now we're going to get into a little bit of the actual immigration law itself and going over whether someone is inadmissible or deportable. So, these both come from the INA. So I'll just go over, right? So what is someone who's inadmissible? So anyone seeking admission, so that means with a visa, adjustment of status, entry at a port, so that could be a airport or a literal port, like a ship, or now a green card holder. LPR, that's a legal permanent resident. So when you see LPR, just think green card holder is returning from travel. So that also includes anyone who entered without inspection. So, notice, these are things that make people inadmissible, right? And then over here with deportability, these are people that already are in the country. And then notice that there's a little crossover, but not necessarily the same thing. So, that's where it really comes back down to the previous slide, right? Where I was saying that you really need to figure out, okay, what actually is this person's status? They said they have papers. What does that mean? Is it a green card? Is it a permanent residency? Is it a conditional residency? Because is it just a visa that they overstayed? Because those types of distinctions can really impact whether, like, how you deal with a plea bargaining case, right? And one thing that is pretty frustrating is that these are, as you can tell, these are pretty nuanced statutes. And what can be kind of frustrating is dealing with clients who obviously they have family members, they have friends who they say, well, my wife or my sister has a green card and this didn't happen, or they were able to take this plea, and you look at it and you're like, well, your sister came in with a visa, you're coming in with a permanent resident. It's actually completely different. So that's something that a lot of immigration attorneys really get annoyed with, because everyone's an immigration expert whenever they're talking with their friends and family. Sometimes it can get pretty bad when your client's been in the jail a long time, because everyone's an expert in criminal law once they've been in the jail after a while. So this is a pretty recent case. This is Blanche v. I'm going to butcher this name, Muk Choi Lau. This is from 2026. So this is from recently. So basically in there, the court held that a border officer can possess clear and convincing evidence at the time of entry and essentially deny a lawful permanent resident seeking admission based on a qualifying crime. So this means that just an LPR, so a green card holder, who, again, doesn't have a conviction, hasn't pled guilty yet, even though they're they're presumed innocent, just like a citizen would be when they're awaiting the disposition of a case, they can be, denied re-entry into the country just based on that. So, this is something that is very frustrating when it comes to dealing with immigration law, is that because immigration law, one, is federal, right, and two, is very politically charged right now, things like this can happen on literally happened like last month, and this is stuff that you need to be on, you need to know. So this isn't something where let me just wait and read the new case law that dropped once a year for the criminal stuff. This is stuff that happens, that decisions can be dropped every month, right? Because there are USCIS policy memos. The immigration deals with the DOJ, with the Board of Immigration Appeals. There's always something going on. So it does that also goes back to, again, why it is important to get a Padilla memo whenever you're dealing with non-citizen clients, because, right, what might be a quote unquote safe plea deal today, right, might not be safe the next day. An example that I often give clients is if it's a DWI, like a first-time DWI charge, and someone wants to say, look, I just want to plead guilty, I don't really want to take this to trial, I don't want to do probation. There's been laws passed, I think at least in the House, didn't pass in the Senate, but it did pass in the House, that would make a one-time DWI conviction make someone inadmissible and deportable, right? So that's something where that hasn't passed yet, but if that ever does pass, you're starting to see why it's a good idea to have that, not only have those Padilla memos, but also just, you really got to keep your eye out on pretty much everything going on with immigration when it comes to Congress and the Supreme Court. All right. So deferred adjudication is a conviction. This is something that even though it's in Harris County with our plea paperwork, it's still, I still get clients that get side blinded by this. So you got to look at the federal definition for what is a conviction, right? And so when you compare that with Texas's deferred adjudication, even though a deferred adjudication, just so I guess we're dealing with people who haven't practiced with criminal law, so let me explain. Deferred adjudication is a type of probation where essentially a defendant says, hey, judge, I'm guilty of whatever the charge is. The judge then essentially takes their guilty plea, sets it aside, gives the defendant a chance to go through probation, and then once probation is completed, the case gets dismissed at the end. So again, if you're a regular citizen, that's in a lot of cases that's a good deal, right? You go through probation, and at the end you get it dismissed, and you can even potentially get a non-disclosure, which means you can help steal it from your record. But when it comes to immigration, not only does it still count as a conviction, so it's almost like, why go through probation and all the fines and fees and the chances of messing up on probation when you could just take a straight up conviction and be done with it. It's almost like, okay, not only that, but you can't even get an expunction, you can't even get a non-disclosure. Even if you do get a non-disclosure and expunction, a lot of times on the federal side, it's permanent. So, someone still has it. Just to really illustrate this, I got hired, I want to say 2 months ago. There was my client, his former attorney pled him to deferred adjudication. He had an ICE detainer, and so he pled deferred adjudication on a felony. What happened, right? He goes to ICE detention. He sits in ICE detention for 6 months. What happens is he gets a warrant and a motion to revoke his probation for failure to do probation, which, unsurprisingly, you can't do probation when you're, locked up. And he ended up being transferred back from immigration to Harris County Jail on a motion to revoke his probation. So, he was in this awkward catch-22 where he couldn't, he shouldn't have, that attorney shouldn't have accepted that deferred adjudication when he had that, when he had the ICE hold. So he was locked in this vicious loop. Thankfully, we were able to vacate his plea. I was able to plead him down to a misdemeanor time served, and he was able to go about his way. But this is something that just happened 2 months ago, right? And even though on the plea paperwork, right, it says deferred adjudication is a conviction for immigration, an attorney, I'm not trying to protect a bad attorney. I legitimately forgot this person's name. That was still something that happened recently enough to where 6 months of this man's life were wasted in a detention center unnecessarily. When if another attorney had been present that knew about this, the consequences, he could have been at liberty a lot sooner. So this is just like a helpful kind of guide. So pretrial intervention diversion, which here in Harris County, thankfully, I've practiced in a lot of counties. Not every county does pretrial intervention and diversion, so I do want to give, in case anyone from the DA's office is on the call, I do want to give you kudos for at least having intervention and diversion programs, and a lot of times those are pretty safe for immigration, not only because they end in a dismissal. There's no conviction, right, under INA. Again, deferred adjudication, that's a type of probation that is a conviction. Straight probation, suspended sentence, that is a conviction. Jail or prison time is a conviction. So Class C fine, municipal, that usually is a conviction, but for Class C stuff, we'll get into what a CIMT is later. It's typically not going to hurt someone for that. And then obviously a dismissal, acquittal, or a no bill, all those are not convictions. So for immigration, that would be pretty safe. And just want to make sure. Am I good on time? Yes, no?
Yes, you're good.
Okay. Yeah, so this is pretty important here. The 360, literally the importance that a day makes. So, if someone is convicted for an aggravated felony and the sentence is up to 1 year, right, that can make someone inadmissible or deportable. Whereas if the sentence is literally 364, less than a year, that can have like a different outcome, right? So, and again, this is stuff that I'm more than happy to share. It's also a lot of, that's a nice thing about dealing with immigration law specifically, is that this is a part of the law where a lot of nonprofits, a lot of firms post a lot of great resources for free because they want people to, have this information there. So now we're going to get into the 4 kind of danger categories. So these are the type of crimes where, automatically you're going to, have your guard up, right? So these are like the worst aggravated felonies. That's kind of like the worst label in immigration law, right? So these are the ones where I have someone come to me with like a sex abuse of a minor case or drug trafficking case or anything that kind of deals with fraud, and I'm thinking, okay, if we take a conviction on this, right, that's going to be pretty catastrophic as far as immigration goes, because as you can see, it triggers mandatory detention, no immigration bond hearing, it makes you ineligible for cancellation or removal, asylum, voluntary departure, permanent bar to good moral character. It says aggravated felonies, but again, that's just the federal reading of it. someone wants to mute, please. That's just federal reading of it, but even a Class A misdemeanor in Texas with a 365-day sentence can be an aggravated. It kind of just depends. So you kind of have like a few of the like the big ones here, right? So another one, I think I mentioned CIMTs before. That's crimes involving moral turpitude. So it's kind of like an old timey. I think like the because when's the last time someone heard the words moral turpitude, right? And it kind of came from like the 1800s, but it's basically conduct that's inherently base, vile, or depraved in practice. So reckless alone is not often enough. So a lot of times you think about like fraud, forgery, credit card, aggravated assault, burglary, indecency, and a lot of these you'll see often held, contested. What counts as a CIMT and what doesn't count as a CIMT can vary depending on what federal circuit you're in. So what here in the Fifth Circuit can be constituted as a CIMT isn't necessarily what would bar someone under the Ninth Circuit or in the Second Circuit. So you see how it gets very granular, and unfortunately for defense side, immigration side, or on the relief, practicing in the Fifth Circuit is pretty rough because obviously the Fifth Circuit has not been they're not super defense friendly when it comes to the criminal side or the immigration side. So this is just kind of going over a lot of those, right? So you can kind of take a reading of that. Another one, controlled substance offenses. So kind of like a carryover from war on drugs. So it's both for deportability and inadmissibility, right? So a lot of this when it comes to heroin or meth, those are also charges that can really torpedo, really just torpedo any like immigration relief. So that's just something that you want to really be on the lookout for when you are here with domestic violence, firearms, and the rest. A lot of times when it's an assault, family violence, plea, for instance, a lot of times on the plea paperwork there will be an affirmative finding of family violence. So sometimes you can negotiate with the prosecutor to avoid that. I found that at least recently, at least in Harris County, a lot of prosecutors don't want to take that out. They were more likely to do that, I think, a few years ago. My thing is just set it for trial at that point, just because you with domestic violence grounds, you really want to not have that as a conviction for someone. You see with the firearms here, false claim to U.S. citizenship, false failure to register as a sex offender. These are just some of the other ones that, again, I think on this other, there's another slide. Yeah, so I skipped ahead a bit, but these are some of the things that if you were able to negotiate with a prosecutor, any of these are in the red to try and get this, that can really help. But you can kind of start to understand why when you do represent non-citizens and they do have immigration consequences that they want to protect, it really does increase. It really just increase the severity of what someone has to deal with, because it's hard enough going through a criminal charge, right? Because you get arrested, you go to jail, you go through the process, you have to show up to court. For a lot of people, it's very embarrassing to even have your mugshot, to have this be public record, and then there's just like these additional. It just becomes a lot harder when dealing with that. So let me see here. So this is more so. This is more so like getting really granular as far as is how do you know whether a violation of Texas statute is a federal violates federal statute, and there's a whole a Supreme Court jurisprudence as far as what's known as categorical method. So for our purposes, it's not necessarily something that we need to like get into, but for anyone who's interested, the cases are up there, and you're more than free to go and read those. But this is just to give you an idea of the Supreme Court themselves. They've had to listen in on these cases because it's so complex that they kind of need to have heard it so much. So let's go there. Let me see. Yeah, and a lot of this is just kind of getting a little repetitive. I do apologize for that, but it's just there's so much to it, and with the sentencing and structuring. So if you have a good prosecutor who is willing to understand that just because someone is charged with a criminal offense doesn't mean that they need to be hit with all the collateral consequences, because a lot of times it's not collateral for the defendant. It's the main crux of it. A lot of people would be more than happy to take a time served and walk around with a conviction if they're able to stay in the country, but instead they have to kind of deal with this. So again, this is kind of more at like what's at stake, and I can let you guys kind of sit and read that on your own time. Lot of times too, this is more for people if you do take like an appeal. There are various ways. A lot of times, unfortunately, right, this motion for a new trial, a lot of people will be sitting in jail for 4 or 5 years before they think to hire an attorney for a habeas. So I believe this is this is the case that basically said that Padilla does not apply retroactively. So if you're looking at potential appeals, anything before 2010, unfortunately, doesn't really apply. So with Harris County, there's just some stuff for you that if you do end up taking like an appeal and there were Padilla consequences or immigration, this is how you can kind of take some steps with that. Just again, some 4 numbers, the 364 days. This has to do with whether it turns into fraud or deceit offense. There's a 30G exception, and then also this is something that some people get a little surprised by, but there is no right to appointed counsel in removal proceedings. So as opposed to criminal, obviously, right, where someone's liberty is on the line, when it comes to immigration, where arguably people's liberty is also on the line, and also deporting them to potentially dangerous conditions in their home country, there is no right to appointed counsel. There is right to counsel, but not appointed counsel. So this basically is just like some takeaways. So if anyone has any questions, feel free to email me.
All right, well, thank you again, Andrew, for sharing your wealth of knowledge with us today.